Hello aspirants, welcome to PW OnlyIAS. I'm here Harpreet Singh with a daily analysis of the Hindu from 4th of December 2024. So let's begin with today's analysis. This is a QR code where you can basically find this particular PDF along with the other material that is required for your preparation. So what all topics we are taking for today's analysis? This Martial Law, SC/ST Act, Supreme Court Judges Appointment, then we have the COP29 outcome. Then we have the Vizhinjam Seaport. Then we have MH-60 Romeo helicopters and the Defense Acquisition Council. Let's begin with today's analysis. Main topic. See, the interesting thing that happened is the South Korean president declares martial law. For our analysis, please understand that the reason that the president declares the martial law was he saw that the opposition is trying to take the control of the parliament, or some, let us say, unparliamentary activities are going on. So this is what the martial law, and he is basically declared because of that. From the perspective of our study, we have to study what is martial law and the provision with respect to India. Right now, because the situation that has arisen in South Korea is going to evolve with time, and when that thing happens, we will be taking in the topic of international relations. But when we see or hear the term martial law, from the GS2 perspective, and even in your preliminary examination, that can be asked, you can be asked, what is martial law? So with respect to the martial law in other countries, what do you have the provisions, or what kind of provisions do you have in the Indian Constitution? That can be asked very well. So we are taking it as topic 1, and let us see when we talk about the martial law. Now see what martial law is. Firstly, Indian Constitution does not properly define it. So that is why, but still we'll see that what all the provisions are. The concept of martial law has been borrowed in India from the English common law. That is, from the Britishers, are basically from the British Constitution and the British laws, we have basically adopted that concept of martial law. The expression martial law has not been defined. Please understand, it is mentioned in Article 34, but it is not defined anywhere in the Constitution. So, however, it is implicit in the Article 34 of the Constitution of India. COI is basically the Constitution of India, under which martial law can be declared in any area within the territory of India. So we know one thing, that firstly, martial law is mentioned in the Constitution in Article 34, Indian Constitution. It is not defined in the Constitution. And along with it, please understand that it is taken from the British common law. So that is what again is a basic parameter that we see over here. Now, if I move ahead, we should understand what the meaning is, though it is not defined, but we should be understanding what the meaning is of martial law is. See, martial law literally means, what does it literally mean? It means military rule. Now, military rule also, not that that a coup and d'état has taken place and military has taken over, not that. Martial law over here means that it refers to a situation where the civil administration is run by the military authorities according to its own rules and regulations, framed outside the ordinary law. It thus applies suspension of the ordinary law and the government by the military tribunal. It is different from military law that is applicable to the armed forces. So what happens? Let us take an example. Let's give a situation. There is a particular district. In that particular district, the police forces are there, the district magistrate is there, who is going to take care of the, let us say, the law and order situations in a particular district. Now, let us say some riot conditions happen or problems have arisen that even the police is not able to manage it. Then the district magistrate has an authority that he can request the government to call the, let us say, the army there to take care of that situation. That is one case. That is one situation. Another situation is also invoking Article 34, where basically in a particular area, a military rule or military law can be applied, where a particular administration of that complete comes under the control of the military. That is an extreme case. That is an extreme case because the administration cannot be carried by the civilian administration during that time. Now, this is again something very important from the perspective of managing the administration in case of such exigency that happens. That is what we are talking about, a martial law. Now, When we move ahead, please understand, when supposingly in case of India, we're talking about when the martial law is in force in any area within the territory of India, the fundamental rights are restricted. The fundamental rights can be restricted. Indemnification and immunity, it empowers the parliament. This is according to the Indian laws. Parliament to indemnify any government servants or any person for the act done by him. That means an immunity is given or can be given by the parliament to any particular government official or even an army official for any act that is done during the military law is imposed or in work, let us say. Now, act of indemnity made by the parliament cannot be challenged in any court on the ground of contradiction to the fundamental rights. So it is like a blank immunity that is given to even the army officials during that time and along with the other government officials who are listed in the act of the under indemnity. Supreme Court, please understand, declaration of martial law does not ipso facto result in suspension of the writ of habeas corpus. That means Supreme Court has itself mentioned that the writ of habeas corpus, that means unlawful detention of a particular individual, is not restricted over here. So that means declaration of martial law does not itself result in suspension of writ of habeas corpus. That means this was again a judgment that was passed by the Honorable Supreme Court. That is why it has come. So that means a person is put under illegal detention. A writ can be filed in the court also that of habeas corpus that a particular person is being illegally detained. In that case, the court can set that person free. Concept of martial law borrowed from the English common law, as we have seen. In the Indian Constitution, it is undefined. What we studied in the previous slide was an interpretation of what we know from the English common law, right? The expression martial law has not been defined anywhere in the Indian Constitution. No specific express provisions in the Constitution that authorizes the executive to declare martial law is implicit in Article 34. Now, the executive can basically impose martial law using the Article 34. Why this provision has been given? This provision has been given there can be an emergency of such a situation where civil administration cannot manage the conditions that are prevailing, and that time when the military can come and then take over, and that time in order to normalize the situation, this can be invoked. That is what is the martial law. Now let's move ahead. There's a difference between the martial law and national emergency. We need to understand that. Martial law, we know that it is under Article 34, national emergency under Article 352. So few differences. Under the martial law, acts only affects the fundamental rights. National emergency, it not only affects the fundamental rights but also the center-state relation, distribution of revenue, legislative powers between the center and the state, and may even extend the duration or the tenure of the parliament. First. Second, it suspends the government and the ordinary law courts. Over here, it continues with the government and the ordinary law court even during the time of national emergency. Third, imposed to restore the breakdown of law and order due to any reason. On the other hand, it is imposed only on the three grounds: war, external aggression, or armed rebellion. Only these are the grounds on which a national emergency can be imposed. Fourth, imposed in some specific areas of a country. National emergency can be imposed in the whole country or in any part of the country. Fifth, no specific provision in the Constitution. It is only implicit that you derive from Article 34. Over here, specific and detailed provisions with respect to what the national emergency is, how it is basically promulgated, how it is basically the emergency conditions have to be there, or what the powers are there, then who has to revoke it. All these things are mentioned in detail. So that is why these are the differences between the martial law and the national emergency. This can be asked in your paper because we know that how the examiners link it. They're not going to ask you that in South Korea there is a military law, explain the implications. They can ask, but again, let the situation evolve. Then we will understand that. But over here, Martial law is mentioned, automatically this thing becomes important. Next. Topic 2. More cases filed under SC/ST Act due to awareness. Now this is about the SC/ST Act. We'll have to see something with respect to this. This is with respect to the reply given by the minister in the parliament. Now see, few statistics. If I take the 2022 statistics, there were 51,656 cases of atrocities against the scheduled caste and 9,735 cases against the scheduled tribe. Now, and they were basically concentrated in certain states. Obviously, it is going to be various reasons, because the concentration of these scheduled caste and scheduled tribes may be much more in certain states, and depending upon the conflicts that may arise also, those are also the reasons why few states have more conflicts. See, conflicts are there in all the states in one or the other way, but in few it is more. If you talk about scheduled caste, you will be seeing that 6 states accounted for 81%. Uttar Pradesh leading, then Rajasthan, Madhya Pradesh, and other states being Bihar, Odisha, and Maharashtra. When I talk about scheduled tribe, Madhya Pradesh has the highest number of cases, then Rajasthan, Odisha, then we have Maharashtra and Andhra Pradesh. So these are the cases that are reported. Now most of them are under the SC/ST Act also and other provisions also. So we see that there are a lot of issues that the scheduled caste and the scheduled tribe basically face. Now, if someone asks what is a scheduled tribe and scheduled caste, then also please remember that when I talk about scheduled caste, please remember scheduled caste are those people, according to even the judgment that was given by the Madras High Court while giving the concept of untouchability also. If you see the Indian social structure hierarchy, you will be seeing there are Varnas, Brahmins, then you have the Kshatriyas, then you have the Vaishyas, and then you have the Shudras. These are the 4 Varnas. Outside the Varna are the scheduled caste. And this is the rank, this is how the rank decreases. When I talk about scheduled tribe, these are those people who basically have been among the tribals. Please see, if you see the scheduled tribe, understand there is a word known as tribe. Now, these tribes are basically defined on the basis of their cultural characteristics, like they are isolated, economically backward, geographically very distant, not in contact with the mainstream population. So this is again a socio-cultural term. Among them, few backward, which needed special attention. Scheduled tribe, this is an administrative term, because you would be seeing that all the tribals do not get reservation. It is a scheduled tribe who get the reservation. So among the tribes also, the ones who are backward were given the status of a scheduled tribe who were specially administered by the government. So that is scheduled tribe. Okay, now going ahead. Now see, what are the reasons for the crime against the scheduled caste and scheduled tribe? That becomes important for you to understand here. First, caste prejudice and untouchability. The concept of untouchability that the scheduled caste people face, and often discrimination faced by the scheduled tribe also, are one of the reasons why people assume that they are backward, and that is why the problem arises. Second is land disputes and alienation, especially the scheduled tribes. You will be seeing that before the Forest Right Act came, very often the people used to, or the private companies and the government would acquire land, and a lot of discrimination with respect to land, alienation being there, they're removed from their property. All those problems do arise in resulting in a lot of crimes against them. Then economic marginalization. These are one of the most poorest communities also. If you realize that among the scheduled caste, only 5% of the scheduled caste earn more than 10,000 rupees per month. So these are one of the most vulnerable sections of the society who are also poor. Fourth, social and political imbalance. You would be realizing that they have they lie, let us say if you talk about scheduled caste, they lie in lowest in the caste hierarchy, and because of that they tend to suffer from a lot of social and political discrimination. Along with that, scheduled tribes also being an isolated set of people also are treated similarly as backward as a scheduled caste, and that is why they are marginalized also when we see from the political and the social sphere. When we talk about inadequate implementation of the laws, you will be seeing there are various laws, SC/ST Act, Protection of the Civil Rights Act 1955. We realize that lack of proper implementation is basically leading to a lot of crimes that are there. Then political opportunity. People tend to use caste and tribal characteristics as a means for politicization, and that often results in a lot of caste-based violence against the tribals, and then leading to a lot of crimes that are against the scheduled caste and the scheduled tribe people. So these are some of the reasons that are very important. Let's move ahead. Now comes the SC/ST Act that the article mentions. So what is this SC/ST Act? Again, in order to protect the scheduled caste and the scheduled tribe from the various problems that they face, this act was enacted. Now see, it is an act to prevent the commission of offences of atrocities against the scheduled caste and the scheduled tribe persons by other than the SC and STs. Now, it provides for punishment of offences of atrocities committed against the scheduled caste and the scheduled tribe. It authorizes a central government to frame the rules to carry out the purpose of the act. Next, the act is implemented by the respective state governments. This is very, very important. Implemented by the respective state governments and the Union Territory Administration, which are provided due to central assistance under the centrally sponsored scheme for the implementation of the particular act. So that means the central government is aiding them through various means so that the act can be properly implemented and the scheduled caste and the scheduled tribe in the respective states can be protected well. So this is first thing. As we move ahead, what are the offences? This act does not apply to crimes committed between the scheduled caste and scheduled tribes or between SCs and ST. That means a scheduled caste person, scheduled tribe person, or scheduled caste tribe person are fighting. This act will not apply to them. Firstly. Next, there are 37 offences included in the act that invoke pattern of behavior inflicting criminal offences, breaking the self-respect and self-esteem of the SC/ST. Among these are denial of economic, democratic and social rights, as well as exploitation and abuse of the legal system. That means you are exploiting them based because of their because they belong to SC and SC communities, or you are passing such stupid remarks or bad remarks because they belong to these communities, you are discriminating them in various fields, then this act can be invoked. Next, investigation. All offences listed in the act are cognizable. An investigation of offence committed under the act can be investigated by an officer not below the rank of Deputy Superintendent of Police. Then, investigation should be completed within 30 days and the report should be submitted to the Director of the State Police in case of any problem in this. Special courts. The Act clearly states that the constitution of special courts to hear the atrocities and the problems that the scheduled caste and scheduled people are facing, and because in order to expedite the proceedings and justice being given to them, special courts have been basically provided or enacted. For the purpose of providing speedy trial, the state government shall, within a concurrence of the Chief Justice of the High Court, establish each district a court of special, or a special court has to be established in every district. Exclusive special courts shall try offences under this Act on a day-to-day basis. For every special court, state government shall specify a public prosecutor or appoint an advocate who shall be present there and basically represent the community of the scheduled caste and scheduled tribe who have basically been facing the atrocities over there. Then, if we move ahead, punishment. The minimum punishment in most of the cases is of 6 months, while the maximum is of 5 years. In some cases, the minimum is enhanced to 1 year, while maximum goes up to even life imprisonment or even to death sentence also. Section 4 of the Act deals with the punishment for neglect of the duties by a public servant. According to this section, if the public servant is not a member of the SC and ST and deliberately neglects his duties which he should be performed, then he can be punished with an imprisonment of 6 months. So this is again a very holistic provision which is basically protecting the scheduled caste and the scheduled tribe from the problems, atrocities, discrimination that they have been facing through centuries. As we move ahead, the recent amendments have been there. The Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 2015. Now this basically amended the certain provisions to make it more stringent. To strengthen the protection of the SC and ST, introducing more stringent provisions, new categories of offences such as garlanding with footwear, that means you're putting a garland of footwear, forcing manual scavenging, imposing social or economic boycotts, any other social evil that is being committed on them, this also becomes an offence. Sexual exploitation and intentional touching of the SC, ST women also will also come under this act, right? Then that is why practice of dedicating SC, ST women as Devdasis is again considered as an offence under this act. Public servants who neglect duties related to the SC, ST can also face imprisonment. Similarly, we had an amendment further. The SC, ST Act of 2018 required the senior superintendent of police approval before arresting an accused or is removed in case of the offense that is committed. So we realize that this is again a way we see a strengthening of a particular law has been done through repeated time, which is basically aiming at a scenario where the SC, ST are basically having a protection because of the law that aids them or helps them. So as we move ahead over here, we will be realizing that there are still issues that are prevailing that are not resolved. Why? Because there are inadequate resources, like the special courts which every district should have are not there, not implemented. Hardly any district you will be seeing that are having special courts for the trial of SC, ST cases. Then insufficient rehabilitation provision. For those who have suffered from a lot of discrimination and problems, the rehabilitation provision is there in the SC, ST Act, but it is not being done, or basically resources are not delegated for that purpose. Then if we move ahead, we realize lack of awareness. The people who are basically suffering from the issues of discrimination, they themselves, many of them lack that they have this act them to protect them. Lack of awareness of the act, awareness about the knowledge of the provisions or the rights that they have. That is again major the problems. Next is limited scope of the covered crimes. Certain crimes such as blackmailing that leads to atrocities of SC, ST is not explicitly covered under the act. Now blackmailing with respect to SC, ST Act is not covered, but in most of the cases we realize that they face problems of blackmailing also. So what happens, it provides just provision or protection of the SC, ST, but it is not holistic in nature even now. That is what the problem again basically arises. As we move ahead, Justice Mohan appointed the judge of Supreme Court. Now he is a Chief Justice of the Delhi High Court who has been elevated to the status of a Supreme Court judge. So here we will be seeing the aspect. Supreme Court judge is appointed. Composition and strength of the Supreme Court. Please understand how it is appointed. Let us see a brief idea. Composition and strength of the Supreme Court. See, originally the Supreme Court had 8 judges from when the time India became independent, 1 Chief Justice and 7 other judges. The Parliament has now increased the number of judges over the time, and today we have 34 judges, 1 Chief Justice of India and 33 other judges. Now this is what the composition is. Now when I talk about for a judge to become a judge of a Supreme Court, there are certain qualifications that need to be there. So Article 124(3) of the Constitution provides that a person can be appointed as the judge of the Supreme Court if he or she meets the following requirements. A person must be a citizen of India, first. Second, must have served as a judge of a high court for at least 5 years. At least 5 years, or 2 such courts in succession. Alternatively, must have been an advocate of a high court for at least 10 years or 2 or more such courts in succession, or he must be a distinguished jurist in the opinion of the president. These are the cases where a person can be appointed as a judge of the Supreme Court. Now, when we talk about here, we have seen that over this criteria that the Chief Justice of the Delhi High Court has been elevated to the status of a Supreme Court judge. So this is the first thing, whereas served as a judge of a High Court, so at least 5 years. So obviously, the Chief Justice is already served. So based on this criteria, he has been appointed as the judge of the Supreme Court. Now this is the qualification that is required. Now appointment. See, we need to understand that Constitution does provide us a proper mechanism through which a judge should be appointed, but we realize that over the time, this mechanism has been molded by a new system that came, which is known as a collegium system. That is, again, change the manner in which the judges are appointed. Now, this is what the Constitution says. Let us see that first. The judges of the Supreme Court are appointed by the President of India under the Clause 2 of the Article 124 of the Constitution. Here, the President may consult the judges of the Supreme Court and High Courts to make an informed judgment. Now, the word over here, then when the consult came, it is very subjective in nature, whether this consultation means that it is a discretion of the President, or the consultation means that what the Supreme Court judges are saying or the Chief Justice is saying, it will be binding on the President. This concept or the confusion did come up. That is through which the collegium system did arise also. We'll see that, right? Oath of the office. Every appointment of the judge must make and subscribe to an oath before the President. The oath includes a commitment to uphold the Constitution, sovereignty, integrity, and perform the duties without fear and any favor. Now, the thing that we saw in Article 124 over here is that the President appoints the judge and he may consult the Supreme Court judges and even the High Court judges. Now, that consultation word was very subjective. That is why I realized what happened is the collegium system came. We'll see how it is arose, but we'll see this. Collegium system basically means at present, the judges of the higher judiciary are appointed through the collegium system. What is collegium for the Supreme Court judges? The collegium, consisting of the Chief Justice and 4 senior most judges of the Supreme Court, decides on the appointment and elevation and transfer of the judges. This collegium is not mentioned in the Constitution, and it has come out because of the decision that were given by the Supreme Court. Now, please remember, this system was not present in the Constitution. The concept whether this word consultation is binding on the President or not is a reason for this collegium system to arise. So at present, it is the judiciary itself recommends who has to be appointed, and the names goes to the President through the government obviously, and the person is appointed as a judge. Again, there is a tussle between the executive as well as the judiciary also, because the role of the executive is removed in the collegium system. So at present, the collegium system is through which the judges of the Supreme Court, even for the matter High Court, are also appointed. Now, the question that arises is, how did this system originate? Now, please understand. The first judge's case, over here, when we talk about the concept of consultation, here, it declared that primacy of the Chief Justice recommendation or judicial appointment refused to be for congent reasons. Ruling gave executive primacy. That means, please understand this, in simple words, it meant that the word consultation over here was just a suggestion. It is not binding on the President. What consultation? Here, President consults with the judges of the Supreme Court and High Court to make an informed decision. So the first judge's cases said this consultation or this consultation is not binding on the President. That means, because President, whatever action he or she does is based on the decision taken by the government, right? So because the decision taken by the President, headed by the Council of Ministers, is binding on the President. That is why over here, when I talk about President, we talk about government. So over here, the primacy or the major role was given to the executive or the President. That means over here, it is the consultation or the recommendation that the Supreme Court judges or the High Court judges give to the President is not binding. So that means the executive will decide who has to be appointed as a judge. But the situation changed in the second judge's cases, where we realized that Supreme Court said that the collegium system holding that consultation really meant concurrence. What does it mean, concurrence? Concurrence means that whatever the Supreme Court judges are consulting, that is binding on the President of India. That means this nature now changed. What was executive having an upper hand, now the judiciary is having an upper hand. So over here, it was realized that initially the Chief Justice of India and the 2 senior most judges, whatever recommendation that they make or consult to the President will be binding, and henceforth that person should be appointed as a judge of the, let us say, Supreme Court and the High Court. In the third judge's cases, it was realized that the collegium system was further expanded for the Supreme Court judges. That means the Chief Justice of India along with the 4 other judges, what they consult to the President, that decision would be binding on the president with respect to appointment of the judges of the Supreme Court. Now, please remember, in 99th Constitutional Amendment Act was basically enacted in 2014, where the Supreme Court said that the government is trying to intrude on the sphere of the judiciary, and that is why they basically declared this particular act as violation of the constitution and independence of the judiciary and declared it ultra vires, where by this act the government wanted to play an important role in the appointment of the judges, where the judges and the executive, judiciary and an executive, both will have an equal say. But judiciary disregarded this and declared this act as invalidated or ultra vire. So that is why now what is the collegium system? That appointment is done under Article 124. There is no problem in that. But the names are recommended by, with respect to Supreme Court we are talking about, the names are recommended by the Chief Justice of India along with the 4 other senior most judges with respect to who should be appointed as a judge of the Supreme Court, right? So this is what is a major dimension which we see over here, right? Okay. Now let's move ahead. Takeaway from COP 29, topic 4. Now this is important because we have done this earlier also. A brief idea. We have seen that COP 29 basically was under the United Nations framework for United Nations Convention on the Climate Change. Now this is again under this framework, various annual meetings take place. Now those annual meetings are known as Conference of the Parties. That means the members who are basically signed this. This was a 29th meeting that took place at Azerbaijan, Baku, right? Now, Baku, and so what happens is over here is, in the previous meetings also, a lot of discussions took place that how the climate change can be basically the issue be resolved and the problems be resolved. But this was very critical. Why? What used to generally happen is that when we talk about the richer countries or developed nations, they have transitioned towards greener energy. Why? Because they have a lot of money, because transitioning towards greener energy takes a lot of investment. Now, for example, if today we tell India that everybody transitions to electric cars, do you realize that electric car is much more expensive right now in comparison to an ordinary, let us say, gasoline or a petrol car. Similarly, any technology and transition that takes place, we'll be realizing a lot of problems will arise in that case. So the developing and the least developed countries are basically demanding that a certain set of fund and the money should be given by the developed countries, because they are the ones who had created a lot of pollution previously. So similarly, we had in 2009 also a Copenhagen COP, where the developed countries promised that they would be giving annually $100 billion to the developing and the least developed countries so that they can transition towards adoption of greener technologies. Now that did not fructify and did not work out, because what the promises were did not actually come out. So what happened is that this particular meet is also under the United Nations framework for the Convention of Climate Change. COP 29 is also known as a meeting of the finance aspect over here, which had to be resolved. Now when we talk about this event, we realize this meetings becomes very, very important from that perspective. So we realize that there's a concept of new collective quantified goals that we hear. This word basically came in the 2015 Paris Agreement of the 2015 COP that happened in 2015. So what happened is over there, this particular word was there. Now what it basically means, please understand. New collective quantified goal basically refers to the money that would be given to the developing countries by the developed countries to provide the climate finance. Very simple. So what is the agenda over here? To get the money from the developed worlds. So this is what is the money that is being denoted over here. So that what money they will give is going to be decided or had to be decided in this COP 29. That was a major goal. So that means negotiations between the developing and the developed nations were taking place over here. So that is why we realize that this is very important. So that is why though we had done in the previous editorials also, we'll be revising it in this case because the topic was here. Investing in livable planet of all. Now, the focus of COP2 again was finance COP. This is again very simple. What we basically see is this is known as finance COP, finance conference of parties, because we had to decide what would be the finances that the developed countries would be giving the developing nations. So the question that arises is, what was the outcome of the COP29? So there are certain outcomes. See, one is the global carbon market. We'll be seeing implementing loss and damage. These points have been given. Now, please understand, these are the points that are mentioned, but the most important one being, please see, the developed countries have agreed are going to give annually $300 billion to the developing nations. Now, this is the major thing that you should understand. In Copenhagen, the promise was 100 billion, though it was never fulfilled. But over here, though they have promised, and let us see whether it is fulfilled or not. But important thing is, it would be, because they are now saying that the developed world would give this money annually. Next is, let us see over here. If we go to the outcomes one by one, global carbon market. Now, please understand, we have already done this concept of global carbon market, because let us, what happens is, there's a concept of carbon credit also. That means one carbon credit is equal to 1 term of carbon dioxide emission. Now, let us say one company or industry is producing lesser amount of carbon because of the greener technology that it has adopted. So reduction of that is basically helping it earn carbon credit, right? On the other hand, there is one more company which is emitting larger amount of emission than what is allowed. So that means extra emission. So what it can do is, this one that is polluting more can buy the carbon credit from the one that is polluting less. And the one which had invested in the money for greener technology and gained carbon credit is profiting by selling the carbon credit. So this is a way what we talk about carbon credit. More importantly, carbon credit market can be there where this carbon credit is basically traded. Like we trade stocks, right? So trading can be done over there. So that basically helps in a lucrative way through which this investment in the greener technology can basically help you to gain money also, because you are gaining carbon credit. That is why global carbon market has been worked on and created and basically solidified, so that it can basically help in trading of the carbon credits. So this is again a very important decision taken. Next, we have done developed worlds have to give 300 billion. Third, implementing loss and damage support. Now, please understand that this is a special fund that is being created for those countries which are most vulnerable to the climate change. Let us say the small island nations. Now, they are more vulnerable because the moment even 2 feet of water rise will basically let that whole nation being drowned. That is why special effort has to be given to them in order to counter the climate change, and financial aid has to be given. So that is why implementing the loss and damage support and by loss and damage fund basically is put to action under this. Next is, fourth is global energy storage grid pledge. Please understand, we realize that when we talk about the alternating current, AC current, we see that continuously when the supply is coming, it is continuously being generated through various hydroelectric power plants, thermal power plants. But when we talk about the solar energy generation, it can only be generated during the daytime, not during the night time. And whenever during the daytime an excess amount of energy is generated, it has to be stored also somewhere. Then only it can be used during the night time when we are moving towards the renewable energy resources. So what is being told over here is that they should collectively work towards energy storage. That is what is important. So the pledge commits signatories to commit to goal of deploying 1500 gigawatt of energy storage globally by 2030. Next, COP hydrogen declaration launch. The pledge signatories commit to scale up the renewable, zero emission and zero carbon hydrogen production, because again hydrogen is one of the alternative fuels which is a future with respect to the energy market. Next, launch of Hydro for Net Zero initiative. That initiative basically aims to modernize the sustainable hydropower infrastructure. That means rather than focusing on very large scale dams and hydropower, small hydropower generations which are sustainable also, eco-friendly also, and zero emission also, that is being focused over here through the Hydro for Net Zero LAC initiative. Next, Baku Harmonia Climate Initiative. Now please understand, this is in collaboration with the Food and Agriculture Organization, where basically the various countries are uniting for a collective effort so that the climate change in agriculture through adaptation and mitigation can be met. Because we know one thing, that agriculture is closely associated with the climate change. Let us say agriculture basically emits a lot of amount of methane gas. Now that can be very counterproductive to the climate change, right? With respect to, it will promote climate change and issues associated with that. So sustainable agriculture and the problems that are caused could be met through, let us say, a proper collaboration between the agriculture sector through the FAO and obviously the UNFCCC. They can basically work together in resolving these issues through the Baku Harmonia Climate Initiative. Global Energy Efficiency Alliance COP29. The Global Energy Efficiency Alliance has been launched by UAE at COP29 in Azerbaijan following the UAE consensus during COP28. So please understand, this word Global Energy Efficiency Alliance is not the first time being mentioned in COP29. It was first time mentioned in COP28. This should be made very clear. This can be asked in a paper also. But a proper consensus had been reached in COP29, where this initiative highlights the UAE's commitment to reducing the carbon emission and conserving the natural resources by promoting the global collaboration with the various countries. Publication of Climate Change Performance Index, which is basically going to show how the countries are performing with respect to the climate change initiatives that are being taken. Baku Declaration on Climate Transparency, so that whenever the various initiatives are being taken by the government, various governments, they should be in transparent manner and properly transparently declared also. That is how you can basically measure the amount of damage or benefits that the environment is going to experience through the changes and the adoption mechanism that are taken by the countries. Strengthening nationally determined contribution indices. That means in the early 2025, new declarations have to be made by the various countries through which what steps they're going to take in the future in order to counter the climate change would be voluntarily declared by them. That is under the NDCs. So this is again the outcome of the COP28 prelims topics. Topic 5, Vizhinjam Seaport to begin informal operations today. So what is this Vizhinjam Seaport? Again, it is located over here, right? Now, Vizhinjam International Transshipment, please understand, Transshipment Deep Water Multi-Purpose Seaport is an ambitious project that has been taken by the government of Kerala. It is designed primarily to cater the transshipment and gateway container business, which with the provision for cruise terminal, liquid bulk berth and facilities for the additional terminal. So basic focus is on the containers. The port is currently being developed with a PPP model, that is public-private partnership, with the Adani Port Private Limited, and the component structure and design, build, finance, operate and transfer basis. So what does it mean? Designing, building, finance, operating, and then after operation of some time, then you transfer it to the government, which is government of Kerala by Adani Group. It is strategically situated in Trivandrum, Kerala. So if you see the location, it is present over here. The location along with the southern coast of India provides an easy access to the international pathway. So this can be an alternative seaport if developed very properly, can be helpful in countering even Singapore in a long term, because over there also large business from the transshipment. Basically, it is a hub for transshipment and the container business in Singapore. If proper facilities are developed there, the regional development can take place. Along with it, a lot of development of the region can take place. Then it is positioned to compete with the global transshipment hubs like against Colombo, Singapore and Dubai. Now as we move ahead, the port boasts of a natural depth of more than 18 meters, which can be further scaled to 20 meters, because when depth increases, even larger ships can come. This depth is crucial as that enables the port to accommodate even larger vessels and the mother ships. India's initial capacity in the first phase is to set 1 million 20-foot equivalent units with potential of expansion to 6.2 TEUs. That means the capacity can be further increased. The word will come, what is transshipment? Again, that was mentioned, it is a transshipment port. So what is transshipment? Transshipment deep water seaport is a port that can handle large ships that carry cargo from one place to another. It is a deep water channel and a large berth area for loading, unloading goods. So again, basically for the basically those ports which are dealing with the transport of the cargoes that are there. So that means very important with respect to trade and commerce, right? Next, US approves 1.17 billion deal for the equipment of MH-60R helicopter. So what are these helicopters? MH-60R Romeo helicopters India is basically buying. It is the world's most advanced maritime helicopter and the US Navy's primary anti-submarine and anti-water helicopter. Now this is India is basically aiming at buying them. The deal has been approved also. Probably India will sooner being able to properly finalize the deal also, where these can be used as anti-submarine helicopters also and for the naval services also. It is manufactured by the US defense major Lockheed Martin, and it is an all-weather helicopter designed for the state-of-art various avionics and sensors. The helicopter is equipped with a range of missions including anti-submarine warfare, anti-surface warfare, search and rescue operations, naval gunfire support, surveillance, communication relay, logistics support, personal transfer and vertical reemplacements. So again, major requirement. This can be used various places, but again, very specific use can be made in the coastal regions, in the sea regions by the Navy and even the Coast Guards for that matter. The helicopter operates from a frigate, destroyer, cruisers, amphibious ships, aircraft carriers. So again, very versatile in nature. If we move ahead, features carries various advanced features like airborne sensor, sonar, multi-mode research radars, nose-mounted forward-looking infrared cameras. Cabin can accommodate 3 to 4 members, powered by 2 turbo-burst engines. You don't have to remember that. Brief idea needs to be there. Maximum speed of 267 kilometers per hour. Range is 454 kilometers. This is an advantage. A huge range is there. Weapons include torpedoes, air-to-air gun missiles, and rocket launchers are also there. This is important, right? Let's move ahead. Procurement worth this much received from DAC. This is Defense Acquisition Council. Important what it is. Let's understand that. It is the highest decision-making body of the Ministry of Defense based on the procurement decisions that takes place. The main objective of the DAC is to ensure expeditious approval required for the armed forces in terms of capabilities and in the prescribed time frame. So that means this council basically aims at that approval and procurement is done in a very systematic and in a time frame manner, and that is why it was formed after the group of ministers recommended the reforming the national security in 2001, the post-Kargil war. So post-Kargil war wanted but modernization of the various armed forces wings, and over there a lot of new equipments had to be bought. So over there a systematic manner had to be there where transparency is also there. That is why Defense Acquisition Council was formed in order to meet that particular requirement. That is why Defense Minister is a chairman. Please understand, not the Prime Minister, Defense Minister is a chairman. Members include the Chiefs of Defense Staff, the Chiefs of the 3 services, Army, Navy and Air Force. Next, it functions in principle to approve, let us say, 15-year long-term integrated perspective plan. So it is basically works on the plan which is of the future, what has to be bought, and in order to meet the future challenges. So it also plans the future with respect to what has to be bought. Accords of acceptance necessary. That means acceptance of the fact that what has to be bought. Categorization of the acquisition proposal, like to buy, make and buy, make. That means what things should be made in India, what should be bought, and what are those things where components could be bought and another components could be made in India and combined. So these policies are also brought down by DAC. Looking into the issue relating to single vendor clearances, take decisions regarding offset provisions with respect to acquisition. So what we are trying to take is basically, and focusing on transfer of technologies also. So it basically aims at first long-term planning of what has to be bought, then secondly it would be focusing on what has to be bought, what indigenously can be produced, or what mix of both can be done. Along with it, proper clearances in a single way so that the delays are not there, because delays lead to cost escalation. So all these things are basically being worked over here, because when you're buying from other countries, possibility would be if transfer of technology takes place from that country, that will be fruitful for the indigenous production of those armory, or for that matter equipments also. So that is also being discussed, so that overall we are secure also, and the defense industry is also in a positive hands. So that is why this all is being done by the Defense Acquisition Council. Next, multiple choice questions. Question number 1. There are 2 statements. Sorry. Let us do it again. Just a minute. Okay. It's two statements. These are the options. This is the answer D. Question 2 with options. Answer is B. Question 3 with options. Answer is C. Question 4 with options. Answer is D. Question 5. Question. Yesterday we had done the windfall tax. Then options. Answer is C. And this was the analysis of the Hindu from today's newspaper. Hope you liked it and enjoyed it. And we'll continue the session even tomorrow. Take care and Jai Hind.